Namaskar. I, Dr. Sonali Dapsi, Librarian of Raja Peary Mohan College, warmly welcome to all the participants of this national webinar on behalf of Central Library, Raja Peary Mohan College. At first, excuse me, we apologize that our principal sir is unable to attend this function today due to special reason. Today, topics is fair use provisions of copyright for educators and librarian. Actually, we are all academician, so we need this problem and what is copyright, what is fair use. Actually, copyright is an international study of protecting the right of creators of writing performed of artistic work such as book, plays, painting, computer program, sound recording, etc. So, to protect the original work of authorships and author fixed the work in the tangible form of expressions. And how to link the fair use? Fair use, we can reuse copyright protected material under certain circumstances without getting the copyright owner permissions. Actually, it is a lot or vast subject area. This time we attend this program and copyright and fair use. So, Shravani, we request today's topic to introduce speaker. Shravani, over to Shravani.
Thank you, Sonali, for giving me opportunity to introduce our madam. Rama Patnaik has a doctoral degree in Library and Information Science from the Andhra University of Visakhapatnam, India, and a master's and bachelor's degree in Library and Information Science from Andhra University. Her thesis on marketing of library and information services in Indian libraries, present trends and future perspectives was adjudicated as an excellent thesis by the School of Information Science, Michigan University in 2002. She also holds a master's degree in sociology. She had secured gold medals in both master's and bachelor's program of library and information science. She is with IIM Bangalore for more than 11 years now. And before joining IIM Bangalore, she was with two leading national law school libraries. She was a regular resource person for all the workshops conducted by Council for Social Development under the aegis of ICSSR, Indian Council of Social Science Research, for user instruction sessions to faculty and research scholars on academic thesis review of literature using online content for research during 2011 to 2015. She was awarded Emerald LIS Research Fund Award for Best Research Proposal among South Asian librarians in 2012. For writing a research proposal, Dr. Patnaik is also a regular speaker at various national conferences. She has published one book and 15 papers in reputed journals, even course writer for InfluBnet, E-Pathshala, University of Hyderabad, and B.R. Ambedkar Open University programs on library and information science. Her area of professional interest are integrating technology in information services, current trends in management of electronic resources, and creating subject profiles with the instructional design using LibGuides. She was recently awarded as the best librarian by ManLibNet, a network of business school libraries in India. She is a consultant and reviewer of the online course on avoiding plagiarism, Indian edition, published by Oxford University Press in associated with Epigam in January 2018, which is used by many libraries in India. IIM Bangalore, under her tutelage, uses extensive use of technology to manage its collection and disseminate services to its academic community. She has undertaken 3 major projects. Renovation of the library interior, which is recently included implementing RFID technologies to manage more than 2 lakhs of items and introduce self-serve services. IIM Bangalore is currently creating a union catalog of holding of all IIM libraries. Thank you. Thank you, Sonali.
Thank you. Thank you, my colleague librarian, our college, Shravani Das. Thank you, Shravani. Now, I request to Honorable Speaker, Dr. Rama Patnaik, ma'am. Ma'am, can you start your presentation?
I hope it is visible.
Yes, ma'am, it is visible.
Yeah, thank you, Shravani and Dr. Sonali. Good afternoon to all of you. It's always my pleasure and privilege to be associated with any academic institutions which is willing to, discuss on a topic, a significant topic like copyright. And I would be happy to share my perspectives and also the practices that are adopted in my library since last 7 to 8 years. We have been extensively running all sorts of promotional activities to sensitize our community. And today I can proudly say that we have a system at place, we have a guideline, and all our course materials which are used for classroom instructions are actually weighted by these guidelines that are developed by library. So I know that many of us would be not comfortable with the topic as we have not studied law, and copyright seems to be a domain of legal professionals and may not have the degree or the knowledge to put forth our arguments in case of any litigation because we don't have the degree. But I think irrespective of whether we like it or not, this function of extending copyright assistance somewhere pushed many of us to be familiar with it and also sensitize our community about this law. Today my presentation will focus only on the print materials because and on the Indian copyright law, because if we just deal with multimedia and all, I think it becomes 1 hour of time would not be enough to understand the intricacies of using content, other multimedia content. Though I will briefly touch upon the content in terms of databases, journals, and or ebooks that we purchase, and we end up signing contracts or license agreements. So that part I will touch upon briefly because that is where I think the entire responsibility of complying with copyright policies or provisions was shouldered on us. Our laws, I must say, are drawn from British, which is the common law, and unlike the laws of US Copyright Act or the copyright law of US, where everything is explicitly mentioned and leaves very little room for interpretation and scope of any ambiguities. So in India, I think most of the provisions are interpreted in case of litigations, and we are dependent largely on the jurisprudence and also the interpretation by judges in case of any dealing with the litigations. We are not, though we may not be empowered to argue in case of infringement in the court of law, but at least as a librarian we will discharge our responsibility to sensitize the provisions that are available for what we call as instruction in legal terminology, which in turn means about teaching and using content for personal research. So without taking much time, we know that the copyright law of India was enacted first in 1957, and most of the provisions are drawn from the UK copyright, since we were under the British rule. It has so many categories, subcategories, explanations, or the provision that it is purely in legal language, and sometimes it will be very overwhelming to understand and interpret. It took almost 6 months for me to study it and consult one of the professors who teaches in IPR to understand my my knowledge in these limitations and the so-called limitations and exceptions, which allow us to use copyright content, especially in a academic setup, as where teaching, learning, and personal use of research is mainly dependent on the copyright provisions. So the Indian copyright, again, it underwent multiple amendments as to conform, our allegiance to the WIPO, that is World Intellectual Property Rights Organization, and it was amended at least 5 times. So the major one, which is considered as my biggest milestone in the Indian copyright law, is of course the amendment of 2012, where a lot of multimedia content was dealt with to conform to this WIPO treaty that India has signed. So without wasting much time, I just go to what actually constitutes the fair use. We don't use the term fair use. I think in Indian law, the term fair dealing is what used as a synonym for fair use. So I'll just look into what are the limitations once again. Yeah, the Indian copyright actually allows broadly these 8 activities, that is for research, instruction, teaching. And instruction and teaching, I don't know, the terminology of instruction or the term of public library is not defined. And again, it is subject to the way it is interpreted in, whenever a litigation happens. So I think most of you are familiar with the Delhi High Court judgment, where the judge has actually defined the entire set of the terminologies that are embedded in these provisions and apply. Because when we talk about the term public library, we always think in terms of what we know as a public library, as library professionals. So being an academic library, am I a public library? Am I actually leading a public library? But how it is defined. So the public library concept is, again, if public is allowed to come and make use of your resources. So what could be the other definition is funded by, public money. So these are, again, as I said, will be subject to interpretations. Like in our case, we do allow institutions, professionals, organizations to become our member and give access even to the digital content as a part of the membership. But again, COVID has changed all these provisions, and we had actually, I think, a large amount of professionals who are dependent on a library like ours were actually denied access because they couldn't physically visit, and the remote access to this copyright content, or what we call as licensed content, is not allowed for visitors except for your own community. You should also be aware of the treaty, the Marrakesh Treaty that India signed. I don't know whether I have spelled it correctly. Where if you have signed the treaty, I think whatever content, copyright content you have access to can replicated for the benefit of kids or youngsters, I think they can make use of the content. I think that is also allowed. Nowadays, I think data mining is also allowed. Text and data mining and storage and preservation. So some of the activities librarians are familiar with. Some of the activities our librarians are familiar with the copyright issues. When we talk about anything that is left out, whether it is for personal research, teaching, or even allowing access to their watching users. So I just go to the previous slide. So again, what actually is copyright? What information is copyrighted? I think I'll just come to that slide later. Under the provisions, what is already known to us is doing a work in a medium, electronic medium means non-commercial public library. Library can actually possess a physical copy. And if you are having, if you are not having access to a book which is out of print, not available in market, actually the copyright provision allows you to make it a physical or scan copy and then slowly make it and give a limited access. I'll also come to the part of the definition of distribution, actually what constitutes distribution, because when you're using copyrighted content for classroom distribution, in the classroom distribution, we'll have a lot of mechanisms. It is not just taking a print out and distributing in the classroom. With technology enabling this distribution, reaching beyond the physical boundaries, the connotation of distribution in terms of copyright has also changed. And then again, whether unpublished work and anonymous work is also allowed or not. I think that also is allowed. I would rather share this video lecture by one of the professors who also helped me in crafting the guidelines for IQAC. I will share the link. If you have time, you will certainly listen to the lecture and actually spend some about what librarians can do, and especially for how they can actually sensitize the faculty as far as copyrighted material is concerned. So reproduction again, there could be qualitative and quantitative. So if you are talking about in terms of quantity, then how much can be reproduced? If you are talking in terms of quality, then what constitutes actually the grant of a work? So these are some of the connotations which the educator or the librarian can analyze the issue and see that the use of this copyright material falls into the four-factor framework. What falls into US, I think, is called fair use provisions. So I think the Delhi High Court judgment is not challenged in Supreme Court, but I am hearing a lot of other suggestions on this particular judgment. Is very specific to the case, or can we take it as a precedence and also start the scanning on mobile, or also not limit to any number of pages and all. I think all this discussion do happen, but it is always safer to be conservative in using the copyright material, because ultimately the reputation or the potential risk it involves actually dents the reputation of the actually dents. If we are little cautious and conservative about using copyrighted material, I think it can be mitigated to an extent that there shouldn't be any restrictions on using material which is enough for producing or distributing in a class. So there as I said, in Indian context we use the term fair use, because indicator is also fair use is also known as a fair use. The fair use, the terminology is usually used in the context of US copyright law. So in this era of digital age where most of your content you acquire in digital format, whether it is databases, whether it is journals, whether it is ebooks, then how do we going to interpret the contract that we signed while purchasing these items for your library? And then what are the provisions or what are the checklists that we should be aware of in terms of not compromising the fair use provisions, what one is supposed to enjoy as far as the law is concerned. Librarians struggle a lot while signing license agreement. It used to be unilateral in the early years of acquiring digital content. But then again, our laws are not so modern. Yeah. Okay. Yeah, your voice is also not clear. Are you going to fix something or should I continue? Okay. So anytime if there is an interruption, you please let me know. I have switched off my camera because of bandwidth issues. So I will just. Okay. So I was talking about the digital content where when we acquire these databases, journals, and ebooks, I think we struggle mostly with our checklist to see whether we compromise on whatever rights or expanding the concept of fair use to the digital world. Unfortunately, our laws are not as modern as US, where it is not defined what is a secure network, and we don't have a Teach Act, especially for online education. So there are many things which are not available. That's the reason that the owners of using the copyrighted material, especially in a very conservative way, is what will save us from any kind of intended or unintended infringement. So if you look at what materials are used by educators is, when they use this copyright material for course packs. Again, I'm not touching the multimedia content, because even if you look at the streaming services or the OTT platforms, none of them are licensed for educational purpose, even in US. So the public performance rights and other issues will come into picture. But when it comes to personal research also, where you should be taking the content, even if you want to make your presentation or your any of your research item need to be presented in a manner which uses the copyright material. So for every use, I think it is prudent to analyze how you are going to balance between the rights of the creator or who owns the copyright and the needs of like creating a course pack or even for personal research. So this analysis is that there can't be any clear-cut guidelines. So the guidelines could be mostly on the restrictive side, but every use is actually could be a new case, and then you have to struggle with it. But broadly, the library can create a guideline at least to make aware of the faculty that how these copyrighted materials can be judiciously used under the provision of limitations and exceptions whenever it is meant to be distributed for classroom instruction. Again, on the qualitative and quantitative side, I reiterate that the quantity, again, it is reproduction is mentioned, but how much can be reproduced is not written anywhere in the provisions. It is up to, again, the person who is using that what actually constitute. If you use large amounts, whether it constitutes whether it falls under the fair use provision or whether you are using one chapter. Usually, I think many libraries restrict to either one chapter or 10% of the total number of books, though this amount of reproduction is not mentioned anywhere. It is based on good faith or practices where it is not known as flouting the provisions. Again, when it comes to quality, if it is the heart of the book, which actually of much significance as compared to the other chapters of the book, then it is for the instructor or for the user to decide whether he can use it or he should actually obtain permissions. So there are ways like where you don't need permissions, and there could be there could be instances where you end up actually asking permission from the copyright owner. It all depends on the context of the use. So how actually we are deciding whether a copyrighted materials can be used? There are few queries which might help. The intended use, if it is for instruction or it is for creative, or what we call as transformative use. If you are actually reading a poem and writing critical appraisal, then it is a transformative use. Obviously, the law allows you to do that. And then again, the type of content, the peer-reviewed or the creative contents hold more value, and that is where most of the restrictions actually dominate that. But non-fiction and all, is non-fiction or the ordinary works which are not that creative in terms of the academic use. There could not be much of the violation, though the use of such books is very limited in scope, especially for teaching and research. And then how much of the content I'm using, is it more than the accepted use, or if I'm using more, then is it anyway will impact the publisher in terms of the sales of the material. Like if I'm using 4 to 5 chapters of the book, then I'm distributing it and using it again and again for multiple terms and multiple courses. Somewhere the copyright holder or the publisher will be impacted by its sale of because nobody will buy the copies if certain chapters which are taught for a specific course are available freely. So whether I am actually photocopying and selling it. And in Indian context, usually you are libraries just charge whatever is the cost incurred in the reprographic charges. You are not charging on the top of it. It is only like meeting your reprographic charges while giving a photocopied material. So there also the commercial interests come into picture. Like you should not charge for one page at least some 10 rupees or something. So reasonably charged to recover the cost of reproduction. This is, I think, in one of the chapters of a book which I authored along with Dr. Swati Bhattacharya. I wrote about how you actually analyze the framework. And again, the concept of public domain and publicly available also comes into picture. I will touch upon that little late. There is, of course, a lot of difference between what is public domain and what is, publicly available. Yeah, most of the works, the copyright ownership last more than 100 years. So the moment it, this 100 years lapses, let me 60 years plus the age of the author, that constitute more than 100 years. So then it comes to the public domain. Public domain is the works which are out of copyright. But when you say publicly available, you can assume that whatever available on internet today is not free to use. They may not be explicitly mentioned because of various reasons. I think academic works, they use these provisions of Creative Commons licenses, but usually it will not be mentioned when it comes to who owns the copyright. So there again, there is a trick, like it's better to discourage use of content that is available because technology enables you to cut and paste. I think that also there should be some restraint on reproduction using technology. So as I said, like we also own the licensed content apart from the copyrighted material. The licensed content covers the digital content in form of, say, databases, journals, and ebooks. So every the terms and conditions of use of the items, especially for these databases, journals, and book, are explicitly mentioned in this contract. And they also define who can use, like the definition of users, the rights of users, the usage, the terms of use, and how to attribute, or how many session in how many sessions and how much content you can download. All that will be included in that contract, and the library professionals are supposed to create a kind of ready reckoner table because they are not identical to these types of items. Every database will have its own contract and the terms and conditions. So it is really very Herculean task for the library professional to create these things. I think every year there is also some kind of changes in these fair use provisions. Now I think license agreements again are allowing to allowing the text and data mining rights. And nowadays I think even transformative agreements are coming into picture, where your faculty may avail some of the privileges of not paying the APC charges if you're subscribing to certain amount of content from a publisher. So this has to be revised and very iterative. And once you have done the ready reckoner, it doesn't stop there. I think every start of the term, we actually grapple with a lot of these issues of especially creating the course packs for various programs within the institute. I came across this, this is used by Michael Brewer. It is a fair use evaluator. It is a program. You can actually share it among your faculty. It is under the Common Creative License. So whenever you input whatever is the intended use, actually the evaluator will tell whether it is, in favor of fair use or against fair use. So this is one of the important, programs, and there is one credit-bearing course also offered by University of Texas. I think you can actually visit the site. And one book by Kenneth Crews, he also gives some situations where, the case studies where the copyright laws are interpreted as per US copyright law. So some observations, like one-time use, usually repeated users are not allowed without further permission of the owner. And, as far as your institutional content is concerned, whether it is whether the student's doctoral thesis or journal articles published by your institute, because the institute owns the copyright. So unless it is explicitly mentioned, I think, the students who submit this thesis and dissertation may also co-own the copyright. It is in the interest of the institute that it should clearly mention who owns the copyright, especially your institutional publications. I have already discussed about this. Now I'm coming to distribution. So in print world, usually we would reproduce photocopies and then make a binder and distribute. That is one way of distributing the content. Usually the Xerox shop within the campus, I think he does everything, and then we pay the reprography charges and collect the binding material. That is one way of distribution. And your e-learning platform, you can also upload the scanned content, or even the links you share with the links, or you can download the PDF and also post it in the Moodle. This is also one type of distribution. And then creating handouts and subject guides with links, like most of the libraries, they do create pathfinders and subject guides giving persistent links to the content on a specific subject. That actually enables the student to discover the content very easily, instead of wading through browsing or wading through reams of pages or screens, if your library is subscribing to multiple resources, which could be overwhelming. But then again, posting the links, creating handouts and all also constitute distribution. So the license agreement actually deciphers all kinds of distribution methods which are permitted or not permitted in the contract. So it is the onus on the librarians to check what is permitted and not permitted, especially in terms of when the content is distributed in the digital platform. There are good interventions, like if you are very hesitant of using any copyright content and interpreting the copyright exceptions on day-to-day basis, it is always advisable to sign a contract with IRRO, the Indian Reprographic organization. And there are a lot of open access content, there is this movement is very helpful in case of COVID, where the textbooks were not allowed for scanning, or the e-books, the e-versions of the textbooks were also not available during the COVID time. I think many institutions resorted to using the open textbooks. They also come with certain terms and conditions, especially on, we have seen a lot of on economics, on business and management. There could be textbooks on other subjects as well, but I think during the pandemic, this has helped us a lot. There are open educational resources. And as I said, Creative Commons licenses, which are out of copyright, is like if you have created a content and you don't want to go through this method of owning the copyright. Remember one thing, that even if you don't register your work as a copyrighted, you still are the owner. It is not now necessary to register in Copyright Office of your work, because inherently you will own the copyright the moment it is published. So then the Creative Commons license, again, it actually an antithesis to the conventional copyright laws, where if you read them, there are 8 versions where most of the time sharing and using for non-commercial purpose is allowed, and you are not bound to observe any kind of restrictions on how much content could be used or not. So these are some of the interventions which are actually cropped up when there were too many restrictions of fair use, especially in the digital world. As I said, license agreements, they outline the use, reproduction, distribution of copyrighted material, and sometimes they mandate also use of passwords, number of users, reproduction rights, etc., because it is usually an 8 to 10 page document where each and every type of use of the content is explicitly mentioned. And that is where the responsibility of the library professionals expands as far as interpretation of the fair use provisions extensible to the digital world is concerned. We have created one we for our e-journals, e-books and e-databases. This is shared with the faculty, so whenever they are using any digital content, these guidelines are pretty much clear about the intended use, whether it is for private study, course packs, distributing in the classroom, any of that, whatever use that is enshrined in those contracts, we have reproduced that and created a kind of ready reckoner table. I have also published a chapter crafting a framework for copyright literacy, a case study in IMB. This book I got it published with my colleague Dr. Swati Bhattacharya. There's one chapter on that which actually discusses about the copyright literacy. So I have now concluded my presentation. I'm sorry, I think I have taken more than 45 minutes. If there are any questions, I'll be happy to answer.
Thank you, madam, for your nice and illuminating presentations about IPR, PAIN to framework of analysis of copyright, fair use, evaluator, and etc. Thank you, ma'am. And now, if the participants have any question, you can type your question in the chat box of YouTube. The question answer session would be continued by Dr. Krishnanko Shekhar Gayan, the Assistant Coordinator of IQAC. Over to you, Krishnanko.
Thank you. I'm waiting for the questions in the YouTube link.
Meanwhile, I can share my screen to showing this online resource what we created. It is permitted. The para 73 of the Delhi University case mentions about it. But when it comes to using journal articles, again, we are conservative in using only one article from the same issue of the journal. But again, multiple terms and years, I think it will be again constituted as not in good faith. Whether the entire book, so the same book cannot be used. Like if sometimes you may come up with cases where faculty owns their book and want to distribute from that, which is again not allowed, even if they have authored for it. Usually the faculty, when they sign a contract with the publisher while publishing a book, they must co-own for certain reasons, especially if they want to distribute some chapters of the book authored by them to the class, or if they can also reproduce some of the chapters in course of, say, conference proceedings, webinars, or workshops. So usually faculty will not look at the contract, they sign blindly and transfer all the ownership of copyright to the publishers. That is when the situation arises where, you are being an author, you are not owning the copyright, even distributing your own work. Then converting print into digital. I think these are some of the things which we encountered, as far as the copyright issues are concerned. We have collated it. I am sure it goes on extending as we come across new cases of interpreting the copyright fair use provisions in our course of use of this copyright content. So we also did the same thing, like publisher name, and put what is allowed and what is not allowed. Sometimes the downloading a PDF article is allowed, and sometimes only sharing the link is allowed. So you have to read the contract and see what is allowed by the publishers. So sometimes even if the use is mentioned, it will not be explicit. It will say that whatever content you want to use, please seek prior permission, even without any money. So these are the things that we do it every year when the session starts in the month of July. We will revisit this page again after our renewals happen, and then update this. So in course of classroom also, this is the same thing that we use. Then streaming videos. And how to obtain permissions. I think usually in business schools they use case studies. So if you are not having a license using Harvard cases, then you end up using, whatever that is available for free or free by these publishers. So this is again, even when you sign a contract, you have to obtain permissions for specific cases that are used for classroom distribution. So this is very, very slippery slide of extending the copyright assistance to especially the course of during the course of instruction. We also define the terminology. What is education purpose, class handouts, print course packs, learning management systems, persistent URL, what is text mining and what is data mining? Because when we negotiate the contract with our content providers, we want them to define the way we see it and without any, of course, restrictions. So if you look at Cambridge University Press, content, there is a tree structure we created. The red one is like, not permitted. And these are the green ones are all permitted. So if I'm buying content from Cambridge University Press, this is the definition of my fair use as far as the usage of this content is concerned. Yeah, any questions?
Yes, ma'am, there are several questions.
Yeah, please go ahead.
Yeah. One is, can we put copyright books in digital library?
Copyrighted books, as I understand from the question, is print books. So the print books are not supposed to be scanned and put it in a digital, digital platform, and then you start distributing. That is actually clear violation. You can't just do back-to-back scanning of the content and put it in your website for distribution or any medium for distribution. That is not allowed actually. And during COVID times, if you have done that, then you have to buy permissions later, because during COVID time, the complete breakdown of supply chain as far as book supplies are concerned. Yeah. So if for a course you need a book and the textbooks are not available for purchase, I think there are mitigants like, we had this IRRO where it allows also scanning 15% of the chapter of the book, but not entire back to back. I hope I have answered that question.
Yeah, ma'am. Next is, if anybody develops a software or mobile app, then can they get a copyright for that?
See, this is again, software and all will come under patent. It's not copyright. Copyright, I think the copyright and IPR is a larger framework of IPR. So if you are developing an app, then you can actually claim for a patent for using your app. But I have not touched that aspect in my lecture today.
Okay, ma'am. Another participant asked what is the exact thing that IRRO stands for?
That is, you can Google and see, it is a reprographic organization, Indian. I think the complete terminology, I'm not getting it. Though we have signed a contract, I'm sorry. If you Google, you can read it. Actually, the IRRO is an organization which is allowed under the Copyright Board. In fact, in our Copyright Act, there is a provision for Copyright Board where, if you sign a contract like this for reproduction, especially the photocopying part of printed books, then you are actually saved from any infringement, because already they mention in the contract that what is allowed and what is not allowed. They have an office in Delhi. You can Google and actually get in touch with them. It is almost, it is very, very safe. And I advise that every library should take that, license. It doesn't cost much. Maybe it depends on the FTE, the number of students and number of faculty. But it costs about within £1 lakh if you are actually trying to assign any kind of license. Again, you can negotiate depending on the strength of your, constituent like faculty and number of students.
Okay, ma'am. Next is, does the inclusion of graphs and figures in PowerPoint presentations from ebooks for classroom teaching require permission from publishers?
See, usually when we sign a contract for acquiring any ebook, they would mention there, like if you are giving attribution, like crediting the graphs and the charts, whatever that you are using for distribution. If I have understood the question correctly, it is for PPTs in the classroom instruction, right?
Yeah, ma'am.
Yeah, that is allowed. Like, mostly publishers agree that the graphs and charts, you can reproduce it in classroom instruction and distribute it to the students also, because it is within the students and within your own students. And, the ebook policy does allow the fair use of content. But it again depends and differs from publisher to publisher. That you have to check when you sign an agreement.
Even that permission is required if we acknowledge them in that presentation also.
Yes. Sometimes they do ask, like, some publishers would not, unless you have clearly mentioned about it. Otherwise, what they will do, they take your rights for granted and they may not mention it. So it's better that you get it mentioned in the license contract that a portion of the content will be used. But when you're actually publishing a research paper, again, that depends on what is the creative, what constitutes the creativity between the creativity in terms of creating that particular graphics or image. Because sometimes a normal Excel graph like pie chart and all, they're, I think, very easy to reproduce. But if there are complex graphs and graphics which takes a lot of effort to recreate, that means they are not allowed. It's better to take permission. Whenever in doubt, it is better to take permission.
Okay, ma'am. Another question is that we often distribute ebooks from public domains. Does it violate copyright laws?
Depends on what kind of ebooks you are actually putting on public. Like, I think recently there are a lot of discussion on SkyHub, and you have a lot of pirated sites where you will get the PDF versions of copyright books. Usually libraries and institute, they don't encourage the use within their network, because if the publisher gets to know, it is not good for an institute to openly disseminate such kind of pirated content. But yes, I think these are all prohibited as far as institution is concerned. If they are copyrighted, definitely not to put it on public domain.
Okay, ma'am. Another is one of the participant asks that how we will find the copyright laws of various countries together. Means it may vary from country to country. So
yeah, it is jurisdictional. You will find in WIPO site, I think there is one library professional who maintains these, updates these limitations and exceptions whenever countries actually amend their laws. I can share the link after this presentation. I think I forgot to put it up, but on WIPO website, if you do a little bit of research, you will know what are the limitations and exceptions of copyright laws of each and every country who are signatory to the WIPO treaty.
Okay, ma'am. So the question till now are this much only we have received from the participants.
So this concludes the webinar seminar.
Thank you, Krishnanko. Now I request Dr. Krishnanko Shekhar Gayan, the Assistant Coordinator of IQAC Raja Peary Mohan College. I request to you, please deliver the vote of thanks.
Yeah, thank you. On behalf of the Central Library and IQAC of our college, I would like to express my sincere gratitude to our Honorable Speaker, Dr. K. Rama Patnaik, for her beautiful presentations, because as a faculty, we come across all these situations, but we don't know exactly where we violate the rules. So this will be a very informative and helpful for all of us. But 45 minutes is not sufficient to know everything. Yeah, so we look forward for this type of sessions with you in near future also. So thank you, ma'am, once again. Have a good day. Thank you.
Thank you to all, ma'am. Thank you, ma'am.